What happens when the exact government watchdogs, designed to protect the vulnerable, wrap themselves in an impenetrable shield of absolute legal immunity?
Yeah, it's the ultimate administrative paradox.
Right. Just think about that for a second. How do you, as a citizen, fight a system that legally tells you, point blank, that it cannot be sued?
You're basically presented with a door that says justice and recourse on the front, but then you turn the handle and you realize the door is just painted onto a solid brick wall.
Exactly. The mechanisms are there in name, but completely neutralized in practice. Welcome to this deep dive. Today, we have a mission that requires us to look far beyond the clean theoretical lines of how a government is supposed to work.
We're looking at how it actually operates when its back is against the wall.
Right. And to do that, we're unpacking a mountain of incredibly sensitive source materials. And I mean a literal mountain.
Oh yeah, the volume of documents here is staggering.
We are talking about leaked, highly charged audio recordings, extensive medical and legal chronologies spanning over a decade, official government refusals, civil registry data, and correspondence that goes all the way to the United Nations in Geneva.
And our goal for you today is to track a journey. A highly specific, deeply complex journey of a single family.
Because they're attempting to do something that most legal scholars would consider, nearly impossible.
Dismantling the absolute immunity of the Quebec Ombudsman.
Also known as the Protecteur du Citoyen and the Director of Youth Protection, or the DYP.
Okay, let's unpack this, because we need to set the stage carefully here.
Yes, and we are adhering to strict privacy protocols regarding the individuals in these source documents. Yeah. We will not be using any real names.
Right.
We'll be referring to the central figure leading this charge as the Sovereign Father. And at the heart of this storm is his 14-year-old Indigenous son. And surrounding them is their extended family unit, deeply impacted by all these events. They're referred to in the documents as the Clan of 23.
It's crucial for you to understand the core tension we're exploring today. This is not just a localized dispute about, a single social worker making a bad call.
Not at all. We're looking at a trajectory that begins with a severe physical trauma and then evolves into claims of years-long bureaucratic ghosting.
Specifically referencing a highly contested document known as Ref 00349.
Yeah, and that ultimately escalates into a staggering $3.08 billion federal claim, which prompts the direct intervention of a United Nations Special Rapporteur.
It's an escalation that defies belief until you sit down and read the actual...
Right, and to truly understand how a local youth protection case ends up on the desk of the UN, we have to start at the physical trauma, the inciting incident.
Because without understanding the baseline of intense vulnerability here, the rest of the bureaucratic battle kind of lacks...
So the documents anchor us in the year 2021. The news transcripts included in our sources detail a severe targeted attack on 14-year-old Barran.
Stabbed multiple times.
The medical details in the sources are just harrowing. Stabbed in the side, stabbed in the back. And the medical reports note that one of those knife wounds was exactly 1.5 millimeters from his heart.
1.5 millimeters. It's terrifying, and the Sovereign Father's statement to the press really encapsulates the sheer terror of that moment. He's quoted as saying, "It was a long, hard battle. We almost lost him."
Yeah. And when a child experiences that level of extreme intimate violence, the immediate medical crisis, the surgery, the blood loss, that's really only the first phase of survival.
Right. Psychological fallout.
The invisible wounds. And this is where the system is supposed to step in and catch you.
Supposed to, yeah.
Following the physical trauma, the Sovereign Father naturally seeks psychological support for Barran. He reaches out to the provincial health network.
Specifically, the Centre Intégré de Santé et de Services Sociaux, CIS Laval.
CIS Laval. He asks for a psychologist to help his son process this near-fatal event. And according to the source material, that request is outright refused.
Just completely denied. And he makes a very specific plea to transfer Barran's case to the Montreal Native Center.
His reasoning, as outlined in the documents, is incredibly straightforward and culturally vital. He wants an Indigenous social worker for an Indigenous youth who has just suffered a massive trauma.
He's looking for a culturally competent environment for his son to heal, which makes total sense.
Again, the sources indicate that request was refused by the DYP. Now, you hear that and you might think, well, bureaucracies are slow.
Sure, maybe staffing shortages, or maybe there's a wait list.
Right. But the sovereign father makes a discovery that completely changes the trajectory of this case. He discovers that he shouldn't have to beg for this transfer.
Because of a legal mechanism called Jordan's Principle.
And according to the sources, no one in the local agencies ever mentioned this to him. So explain exactly what Jordan's Principle is, mechanically speaking, because it's the fulcrum of this entire initial failure.
Okay, so Jordan's Principle is a fundamental, legally binding rule in Canada. It's named in memory of Jordan River Anderson, a First Nations child from Manitoba.
Right.
Jordan tragically died in a hospital while the provincial and federal governments spent years, literally years, arguing over who should. So the core mandate of Jordan's Principle is designed specifically to prevent that exact administrative violence. It states that First Nations children must be able to access all public services they need when they need them without experiencing any delays caused by jurisdictional disputes between different levels of government.
So mechanically, it means the government isn't allowed to treat a suffering child like a hot potato.
Exactly.
The agency of first contact has to provide the care immediately, and then the bureaucrats can go into a back room and sort out the finances later. The child's care comes first, absolute stop.
Precisely. It is a proactive legal duty. It's not a suggestion. It's a requirement.
Right.
What stands out so starkly in the source audio is the sovereign father's realization that this principle, which was built for this exact scenario, was seemingly entirely hidden from him by the local agencies.
He had to discover it himself while his son was recovering from stab wounds.
Which is just wild.
I want to read his exact quote from the news transcript because the absolute frustration is palpable. He says, Jordan's Principle should be all over in government buildings like DYP and all that. The wall should be plastered with a First Nation help or something. He goes on, you go there, there's toll-free numbers for suicide lines and stuff like that, but nothing for the First Nation people.
If we connect this to the bigger picture, to see the mechanics, literature in our sources calls secondary victimization.
Wait, let me push back on that term for a second, because secondary victimization sounds like an academic buzzword.
It does, yeah.
Are we just talking about really bad customer service at a hospital? Or is there a legal and psychological threshold where bad administration actually becomes a secondary form of trauma?
It is far beyond bad customer service. It's a recognized systemic phenomenon.
Right.
Primary victimization is the initial trauma, physical stabbing by an assailant. Secondary victimization occurs when the victim, or in this case, their family, subsequently engages with the very institutions designed to support them.
Like the police, hospitals, social services, human rights commissions.
Exactly. And instead of receiving support, stabilization, and care, they are met with mechanical coldness. Skepticism, endless red tape, jurisdictional deflections, or outright indifference. The literature argues that this institutional betrayal effectively re-traumatizes the victim, sometimes more profoundly than the initial event, because it shatters their fundamental trust in the social.
It's the system actively compounding the injury. I mean, imagine rushing into an emergency room with a child who has a life-threatening wound.
Yeah.
And instead of a doctor rushing over, you're handed a complex bureaucratic form in a language you don't speak, told you might actually belong in a different building across town, and then asked to legally prove that your child actually deserves a bandage.
It induces sheer panic.
How does a system designed for care become the very thing actively denying it?
That is the exact question that elevates this from a tragic local medical issue to a massive human rights issue. Because when the health and social service system allegedly fails this profoundly, citizens in a democratic society are supposed to have a safety valve.
They're supposed to have recourse. They turn to the watchdogs.
Right. So the sovereign father realizes the hospital and youth protection are legal. When the internal system closes ranks, you have to.
That's why he turns to an independent civil rights organization, the Center for Research Action on Race Relations, known as CRAO.
According to the timeline, the sovereign father posts about his agonizing experience online. CRAR actually reaches out to him.
Wow. And they sit down and review the entire chronology. They look at the severe nature of the stabbing, the immediate refusal of psychological services from CIS Laval, the refusal by the DYP to transfer the case.
Federal rights under Jordan's Principle.
Right. And CRR's conclusion, based on their extensive review of his documents, is severe. They identify what they allege is clear systemic neglect and a blatant denial of rights guaranteed under Jordan's Principle.
So they don't just write a strongly worded letter. In April 2024, CRR takes formal legal action.
They file a comprehensive complaint on behalf of the family with the Quebec Human Rights and Youth Commission.
Okay, so you have a major respected...
As a citizen, you'd think, this is it. This is where the oversight kicks in. The watchdog is going to step in, investigate the DYP, and fix this.
But the system doesn't do that. The commission drops the case.
They just drop.
And the stated reason for dropping the case is arguably the most critical pivot point in this entire deep dive.
How so?
Well, the Human Rights Commission doesn't say, we investigated the DYP and found that everything was handled perfectly. And they say, essentially, our hands are legally to act.
Because of the immunity clause.
Exactly. According to the statements provided to the media and outlined in our sources, the Youth Protection Act contains a specific ironclad clause.
Okay.
It grants absolute immunity to the Director of Youth Protection and their staff. It explicitly states they cannot be sued or legally pursued for actions performed during the course of their duties, provided those actions were made in good faith.
In good faith. Those 3 words are doing an unbelievable amount of heavy lifting here.
Absolutely.
The commission claims that because they cannot explicitly legally prove that the youth protection staff acted in intentional bad faith, meaning they didn't write down, we are doing this to hurt the child, the immunity holds firm.
Yeah.
And if the immunity holds, the Human Rights Commission declares it simply lacks the statutory authority to investigate further.
What's fascinating here is the legal... Why does such a massive...
Why let them off the hook?
Historically, it's instituted for a logical reason. To allow social workers, police, and government officials to make incredibly tough, high-stakes decisions, like removing a child from a dangerous home in the middle of the night.
Without the paralyzing constant fear that they will be personally sued into bankruptcy by angry parents at every single turn.
Exactly. It's meant to protect the function of the office so it can operate decisively.
I get that. You don't want a social worker hesitating to save a kid because they're worried about a lawsuit. But let me push back on this application of good faith.
Okay.
If I'm a social worker and I act with extreme, blinding incompetence, I ignore a federal law like Jordan's principle, I deny psychological care to a stabbed child, but I just smile and say, hey, I meant well. I was just following my office policy. I'm immune.
That's the loophole.
The executive director of Selectoria points out how terrifying this loophole is. I'm reading directly from the news source here. The worst thing is if systemic racism or even intentional racism is not considered an act of gross negligence, and where it's not considered an act of bad faith, then we should be worried about how racism is being dealt with by the system.
It is a profound critique. CELARR is highlighting a structural flaw in the law. How exactly is good faith measured by a bureaucracy when the outcome is catastrophic? If the documented result is the gross neglect of an Indigenous child who has just survived a murder attempt and the complete failure to inform the family of their federal rights, how can the system internally investigate it and conclude, well, there was no provable malice, therefore we meant well, therefore we are immune?
It's a perfect, impenetrable loop. The system fails you. You complain to the official watchdog. The watchdog says, we can't investigate the system because the law legally assumes the system is acting with good intentions unless you can prove otherwise.
Which you can't because we won't investigate.
It's the illusion of recourse. It makes the public feel like there are robust checks and balances. But for the sovereign father, he realizes he's in a legal Faraday cage.
Exactly. No matter how much evidence of negligence he broadcasts, the signal cannot penetrate.
So when a citizen hits a brick wall at the Human Rights Commission, where do they go?
They escalate. They go to the ultimate...
The Protecteur du Citoyen, the Quebec Ombudsman. This is the apex of the provincial watchdog mountain.
It is.
And this is where we need to look incredibly closely at a specific file in our sources. Document 2600349.
Right.
Because the sovereign father, completely blocked by the Human Rights Commission, takes the sprawling case of Barran and the Clan of 23 directly to the Ombudsman. He's asking the highest authority to pierce this veil of good faith immunity.
And the response they receive from the Ombudsman's office is a masterclass in administrative finality. We have the actual document in our source files. It's an official communication signed by a delegate named Melanie Ouellette.
Let's really look at the mechanics of the language in this refusal, because it is stark. It's written in French, so let's translate and analyze the specific text.
Let's do it.
The Ombudsman's office states that despite the sovereign father's extensive documentation and obvious dissatisfaction, they assure him that his files have been the subject of an examined, complete, objective, and impartial. A complete, objective, and impartial review.
So they lead with a declaration of their own thoroughness, but they provide absolutely no breakdown of how they conduct this review. or why they reached their conclusion.
Just trust us, we looked at it.
Right. And then comes a decisive blow. The document states, Nous vous informons que le protecteur du citoyen n'interviendra pas davantage. We inform you that the protecteur du citoyen will not intervene further.
Will not intervene further, full stop. No explanation of the legal rationale. No response to the claims about Jordan's principle.
And they don't stop there.
No. There's a final warning at the bottom of this document that is genuinely chilling when you think about the power dynamics at play.
It really is.
It says that any future emails or documents sent by the Sovereign Father that do not bring profoundly new elements will be simplement classés à votre dossier et aucun accusé de réception ne vous sera acheminé.
His dossier and of receipt will be sent to him.
They are formally, legally ghosting him. They are telling a father, we are putting your pleas for your stabbed son into an administrative black hole. We will not read them, we will not act on them, and we will not even give you the dignity of an automated computer email saying we received it.
It is of silence. And to truly understand the weight of this dismissal and why the Sovereign Father finds it so, we have to introduce another piece of source material. We have to look at the precedent set by this very same Ombudsman's office. System. And
this is the part of the deep dive where the institutional hypocrisy becomes glaringly obvious.
In that 2016 report, the Ombudsman was absolutely scathing in its criticism of vulnerable citizens seeking help. The report explicitly condemned the state agencies for their restrictive interpretation, heavily criticized them for not providing clear, transparent reasons to victims for why their claims were being denied.
2016 report literally states that the bureaucracy's formalistic stance forces traumatized, vulnerable citizens into exhausting, years-long litigation just to get basic services they are owed.
Exactly.
The Ombudsman in 2016 was acting like a true watchdog, barking loudly at the system for hiding behind red tape and legalese to deny care.
Yet exactly 10 years later, in document 26000349, we see the Ombudsman's office exact same restrictive, dismissive, and formalistic tactics against the Sovereign Father and Barran that they previously condemned. They offer a boilerplate refusal, they claim absolute objectivity without showing their work, and they shut down communication entirely without transparent justification.
According to the arguments made in the sources, it is institutional gaslighting on paper. You have the state's ultimate watchdog doing the exact thing they publicly flayed another agency for doing a decade prior.
Yeah, the irony is...
So put yourself in the shoes of the Sovereign Father. The local hospital ghosts you. The Human Rights Commission claims they are powerless because of immunity. And the ultimate Ombudsman formally tells you they are sending your emails to a black hole. How do you fight back?
What is the legal mechanism to break a system that has legally sealed itself shut? Is a legal fiction in this specific context. You have to find a legal precedent proving the Ombudsman and the DYP can be defeated in court.
And the only way to destroy the assumption of good faith is to expose a timeline of systemic rot so profound, so long-lasting, that no reasonable judge could look at it and say they were just trying their best.
So you need overwhelming, undeniable evidence of bad faith over an extended period. Which brings us to the core of the Sovereign Father.
File now. 500-04-06-1847134, also referred to in the sources as the plumulative civil evidence. Now, explain to me how a plumulative works, because this is a specific Quebec legal mechanism that changes the entire scope of the story. This nightmare didn't actually start with the stabbing in 2021, did it?
No, it didn't. The plumulative is the public civil and criminal registry in Quebec. It tracks every single motion, every judgment, every interaction a person or a family has with the court system.
Okay.
And what the plumulative data in our sources reveals is that the stabbing of Barran was, according to the civil registry, of 13
years.
Documents show that state involvement with this family through the courts and youth protection began way back in August 20.
Over a decade. The sources list multiple continuous judicial interventions. Initial judgments rendered by Judge Big and Julie back in 2013.
Yeah.
Years of grinding, continuous legal proceedings regarding custody, living environments, and protective orders before Judge Gagnon Alain and several others between 2014 and 2021.
The legal architecture the Sovereign Father is building here is one of systemic exhaustion. He isn't just complaining about one bad interaction with a triage nurse or one dismissal.
He's showing a pattern.
The plumative civil data is presented as irrefutable state-verified evidence of a decade of state failure, stability, or a safe environment for Barran. A decade of court orders that ultimately failed to protect a child, culminating in a near-fatal stabbing.
And the sources allege that even after the stabbing, from 2021 to 2023, despite the Director of Youth Protection being intimately involved in the case, no final resolution or adequate trauma-informed psychological services were provided.
Right.
But how exactly does this 13-year history of court dates legally pierce the immunity of the Ombudsman? What is the actual lever he is pulling here?
The lever is found in the precedents surrounding the Tribunal Administratif du Quebec, or the TQ. The TAQ is a highly specific independent judicial body in Quebec. It is composed of administrative judges who actually possess the statutory power to review and overturn decisions made by state bodies, like IVC, the DYP, and by extension, gatekeepers like the Ombudsman.
Okay, so the TAQ is the court that watches the watchdog.
Exactly. And the critical legal precedent, which ironically is noted in the Ombudsman's own 2016 report, states that the state has the implicit power and the moral to reconsider and overturn administrative decisions that are marred by an error so serious as to invalidate them.
An error so serious as to invalidate them. That's the magic phrase. That is the legal threshold to break immunity.
Correct. The Sovereign Father's argument is built entirely on meeting this threshold. He is presenting 13 years of documented failure in the civil courts, plus the subsequent total failure of the agencies to implement Jordan's principle. And finally, he is presenting the formal, written administrative ghosting by the Ombudsman.
He argues to the courts that this entire sequence cannot possibly be classified as good-faith bureaucratic friction.
Right. It constitutes an error so unbelievably serious and a manifestation of systemic bad faith so profound that the statutory shield of absolute immunity must legally dissolve.
He's essentially saying to the TQ, you cannot look at a 13-year paper trail of state failure, ending in a near murder and a complete denial of psychological care. Look me in the eye and tell me these agencies were operating in good faith.
Precisely. He is attempting to create a new, undeniable jurisprudence. He is arguing that if a system's neglect is severe enough and documented extensively enough through the state's own plumative registry, immunity cannot be used as a blunt instrument to silence.
But here's the reality of navigating the TQ. As the sources point out, it is incredibly daunting.
Oh, absolutely.
It requires a traumatized, exhausted family to act as their own legal advocates against state lawyers in a highly adversarial, complex legal setting.
Quickly explains the sheer desperation, the exhaustion, and the radical escalation we hear in the leaked audio transcripts.
Right.
To the DYP, to the Human Rights Commission, to the Ombudsman of immunity, and the only way out is a massive, complex battle in the TAQ. You have to take radical action.
You have to elevate a child welfare case to a level the state simply cannot ignore.
You elevate it to a matter of priority.
This segment of our source material is incredibly intense. We are looking at verbatim audio recordings prepared for a UN rapporteur and legal aid in April 2026, where the Sovereign Father is on the phone.
Yeah.
But he's not just calling the local DYP anymore.
No, he's escalated way beyond that.
He is calling the RCMP and CSIS, the Canadian Security Intelligence Service.
Yeah.
Now, I have to stop here and play devil's advocate. Calling national intelligence spies over a provincial youth protection failure. Isn't that an immense overreaction? How does a child's care file become a CSIS issue? Okay, what does he say?
On these calls, he identifies himself as a sovereign leader. He states he is triaging 13 people in a security vacuum, referring to the extended family plan of 23.
He's literally telling the federal intelligence agencies, I am dealing with a domestic emergency. The state is using administrative ghosting as a form of medical torture against an Indigenous family.
Yeah.
And he drops this shocking, deeply personal detail about his own health on these calls, too. He tells them he is dealing with a 100% total coronary blockage while trying to fight this multi-front battle for his family's survival.
If we connect this to the bigger picture, the leap to calling CSIS makes perfect sense within his legal framework. When a citizen realizes that the entire domestic, judicial, and administrative apparatus is actively legally ignoring them.
When the highest provincial watchdog tells them their pleas are going into a black hole.
Exactly. It ceases to be a mere civil dispute about social services.
Right. To him, it's no longer about paperwork. It becomes a fundamental structural breakdown of the social contract between the state and the citizen.
It becomes a literal existential threat to the security and survival of his family. The security vacuum he references to CSIS is the complete and total absence of state protection. So he is calling the federal government's ultimate security apparatus to report that the provincial state has gone rogue. And that realization triggers the ultimate legal escalation found in the sources, the federal emergency filings, and the massive financial claim.
Let's get into that. The sources outline an emergency motion, specifically citing Rule 374, filed on March 24, 2026, at 11:38 p.m. with the federal court.
Late night filing.
Yeah. And tied to this federal motion is a staggering $3.08 billion federal claim against the system. Now, let's talk about Rule 374, because it's not just a standard lawsuit.
Rule 374 in the federal courts deals with emergency motions, often brought ex parte, meaning without the other party present, because the matter is of such extreme urgency that waiting for a standard hearing, he is using the highest emergency lever the federal court has.
And then there's the number, $3.08 billion. Now, you're probably hearing a $3.08 billion claim and thinking, okay, this is frivolous. Nobody sues a provincial agency for $3 billion over a single family's case.
It sounds like a random lottery ticket.
Right. But looking at the legal strategy in the sources, what is the actual mechanism behind that specific massive number?
Analyzing this through the lens of legal strategy, the massive monetary claim is arguably less about expecting a direct literal payout of $3 billion and more about creating an undeniable forcing function.
A forcing function.
When you file a claim of that magnitude, it triggers mandatory risk assessments at the highest levels of the federal government. It is a calculated shock to the system. The goal is to make the potential liability so massive, so catastrophic, that the federal gatekeepers are legally forced to look at the underlying cause, the absolute failure and bad faith of their provincial agencies. He is trying to price the province's immunity out of existence.
He's basically saying, you want to ignore my son's stab wounds? Let's see if you can ignore $3 billion of federal liability.
Exact.
But even with this massive strategic escalation, he hits another wall. In the audio transcripts, he is absolutely furious at what he calls the clerk, who physically intercepts the filings before they could ever reach a federal judge's desk. He says in the tape, it's the clerk that has the key to go give this to the judge.
The frustration recorded there is absolute. Federal bureaucracy of acting as a secondary shield.
The system is protecting itself by not even allowing the judge to see the file.
Yes, and this is why his anger turns toward the highest symbolic and political figures of the state in these calls.
Yeah, he calls out the Governor General's office. He points out what he views as the deep, sickening hypocrisy of the state-sponsored orange shirt move,
which honors Indigenous children who suffered in residential schools.
Right.
It's a powerful indictment. Look at the map of escalation. The province claims absolute statutory immunity. Years of exhaustive litigation block emergency access to the federal judges.
The domestic avenues for justice, for all practical purposes, are completely exhausted and sealed shut.
And when the nation state formally refuses to acknowledge your human rights, there is only one remaining authority.
The international community, the United Nations. This is the absolute climax of the documentary evidence we have been analyzing.
Our sources contain official correspondence dated April 7, 2026, originating directly from Geneva. It is from Dr. Albert Kwokwo-Barum, the United Nations Special Rapporteur on the...
And this document confirms that the UN has officially acknowledged receipt of the Sovereign Father's massive submission. They have the 13-year Plumatif data, the audio, the Ombudsman's refusal. They are formally looking at the case.
They are.
Now, does the UN letter actually have teeth domestically? Does the province of Quebec care if Geneva is watching?
The moment that letter is sent, the entire legal and political battleground shifts. It may not instantly force a provincial social worker to act, but it fundamentally changes the gravity of the legal liability. This is no longer just a localized, easily dismissed civil part of an active...
And it highlights a glaring, uncomfortable hypocrisy on the world stage, which is detailed extensively in the source document titled Reparation and the International Criminal Court. Let's unpack the contrast here because it is sharp.
Oh, very sharp. Globally, Canada funder and champion of the International Criminal Court, the ICC.
Right.
Canada advocates strongly at the UN for the declaration of basic principles of justice for victims of crime. The cap and that victims of state violence globally.
Right. It's like spending millions of dollars to build a state-of-the-art security and justice system for your neighbor's house across the street. You travel the world lecturing everyone on how vitally important it is to protect the vulnerable and pierce the immunity of corrupt states. Exactly. Your own internal security guards, your human rights commissions, your ombudsman are claiming good faith absolute immunity while completely ignoring the trauma of an Indigenous child bleeding in your living room.
It is a profound paradox that the Sovereign Father's legal strategy brilliant. Domestically, the evidence suggests Canada's own tribunals, commissions, and ombudsman offices are utilizing bureaucratic immunity to ignore an Indigenous victim within their own borders. Internationally, they preach the exact opposite.
So mechanically, how does this UN letter change the game for the $3.08 billion claim?
Well, by gaining formal acknowledgement from the UN Special Rapporteur, the Sovereign Father essentially bypasses the provincial immunity shield entirely. The province might say we are immune, but the UN does not recognize provincial administrative. He is validating the premise of his massive federal claim by framing the 13-year neglect, the failure of Jordan's principle, and the subsequent administrative ghosting, not as a simple bureaucratic error, but as an ongoing, documented international...
It forces the domestic federal courts to eventually reckon with the fact that the international community is now watching how they apply good faith immunity. They can't just have a clerk sweep it under the rug anymore. Wow. Let's try to summarize this staggering journey we've just unpacked for you. What began as a terrifying, visceral physical attack on a 14-year-old boy, a knife wound 1.5 millimeters from his heart, evolved into a second, arguably much more insidious attack by the state.
It evolved into a wall of administrative ghosting, weaponized statutory immunity, and profound institutional silence, all justified under the guise.
But through relentless, meticulous documentation gathering, 13 years of civil registry files, recording intelligence agency calls, exposing the hypocrisy of previous ombudsman reports, and filing emergency federal injunctions, the Sovereign Father, fighting for the survival of Barran and the Clan of 23, has taken a local grievance all the way to the desk of the United Nations in Geneva.
He is attempting to shatter the legal concept.
And as you listen to this, you might be asking yourself, why does this highly specific, complex legal battle in Quebec matter to you?
Right.
It matters because the mechanisms of absolute immunity, the good faith loopholes, and the power of administrative ghosting exist in virtually every major institution you interact with, whether it's your local school board, your hospital network, or your municipal government.
Exactly. The legal precedents being fought for in this case, the attempt to prove that a watchdog like the Ombudsman cannot simply declare we will not intervene further without facing massive accountability, could determine whether any citizen can hold a powerful bureaucracy accountable when they utterly fail to do their jobs.
It's about whether the door to justice is real or just painted on the wall.
If a government agency possesses absolute, legally impenetrable immunity from the very citizens it is designed to protect, you have to ask a very uncomfortable question. Only serve to protect itself.
And when the state abandons its fundamental duty to protect its most vulnerable and legally seals off all avenues of recourse, at what point does a citizen have the moral right to declare themselves entirely sovereign from that state?
Dive leaves us with.
Keep questioning the system, keep demanding to see the mechanisms behind the curtain, and we'll see you on the next deep dive.